Gayane Aghajanyan, and I will be moderating this panel. We will discuss the importance of universal jurisdiction in prosecuting serious human rights violations, including war crimes, to promote accountability where it might otherwise be absent. Today, we'll hear our experts to share their experiences in leading the cases against other states by using universal jurisdiction and the challenges they face in doing so. Without further ado, I would like to introduce our first speaker, Mr. Hawre Ahmed. Mr. Ahmed is the founder and executive director of the Kurdistan Center for International Law, where he is leading a project for criminalizing core international crimes in the Kurdistan region of Iraq. Previously, he has published a book on genocide in international law and tribunals in Kurdish language, and was a co-author of a study on limitations and obstacles which hinders the Kurdistan judicial system. Mr. Ahmed has published articles on Yazidi genocide, war crimes, and crimes against humanity in Iraq. The stage is yours.
Thank you so much. I'm very proud to be here, and I would like to thank Galen and Cassia for your kind invitation. I'm going to talk about the National Criminal Kurdistan region of Iraq and ISIS accountability. How can I change the slider here? Thank you. Yeah, but before going to talk about ISIS accountability, I would like to bring you back to 20 years ago, after the liberation of Iraq, or invasion of Iraq, it depends on your perspective. Iraqi High Tribunal was established and it operated from 2005 to 2011. The temporal jurisdiction was from 1968 to 2003, and the personal jurisdiction was just for the members of the Ba'ath Party, the Iraqi citizens, and the subject matter of the subject matter jurisdiction of the court was for the crime of genocide, war crimes, and crimes against humanity, and of course any other ordinary crimes within the Iraqi Penal Code. The most well-known judgment is within the Iraqi High Tribunal were the cases which were related to the Kurdish community, Halabja case, Anfal case, Faili case, and Barzani case, which all of the cases were amounted to war crimes against humanity, and genocide. My reflection to the Iraqi High Tribunal, the tribunal was serving as retributive justice instead of transitional and restorative justice, because within the rules of the court there were trials for prosecuting core crimes, but outside the court there were conflicts, many different conflicts among many different religious and ethnic groups. The court was not served to become a foundation for incorporating international criminal law, which we would have needed in 2017 for prosecuting ISIS fighters. And of course, the court didn't have any sufficient professionalism of the court and of the judges and of the staff. ISIS emerged in 2014. International states emerged. ISIS didn't come. ISIS emerged within the Sunni society. I was around 100 kilometers far from ISIS. Village by village, town by town, city by city, they joined ISIS because of the political dynamics and because of not having restorative justice after the fall of Saddam Hussein. And when ISIS defeated, there were some demands from the international communities or some of the victim organizations to prosecute ISIS fighters at the ICC. But Fatwa bin Saud in 2015 rejected, the initiation. And all of the ISIS fighters, they have been prosecuted both in Iraq and in Kurdistan according to the anti-terrorism law. And when it was, when the case of Iraq was established by the United Nations Security Council in 2017, and it will be ended in this week in 15 September 2024, they already collected many evidences, but they didn't share any evidence with the Iraqi and Kurdistan courts because they say it's against the United Nations standards, because both of the authorities in Iraq and in Kurdistan, unfortunately, we have capital punishment. In 2021, we have conducted this research when we established Kurdistan Center for International Law. I would like to share some of the data within our research. We collected data from the Kurdistan Court of Cassation in the felony committee in the Kurdistan Court of Cassation. 44% of the cases were related to the anti-terrorism law. It means 44% of the cases were related to ISIS crimes. And in 2021, it was 39%, and in juvenile committee in the Kurdistan Court of Cassation in 2022, it was 36% and 24% in 2024. In 2021, Kurdistan Parliament initiated a discussion for establishment a special court for ISIS crimes. I was actively involved within the discussion for establishment the special court. But while we were in the discussion for establishment of the special court, the Iraqi Constitutional Court issued a judgment and said the special court for ISIS crimes is unconstitutional. So they blocked the vote and we returned back to the first square. In 2022, we as the Kurdistan Center for International Law, we started again another discussion for just answering this question: Kurdistan would be able to criminalize war crimes in its judicial and legislative system or not, because there was no way for prosecuting ISIS. So fortunately we found out yes, we could. All of these researches are available on our website. We started to draft a law for criminalizing war crimes. We already have cooperation with some national and international experts. So the draft law is available on our website, and we have submitted to Kurdistan Parliament. But it needs to be like more advocacy for criminalizing war crimes, because there is not like public awareness raising about the importance of the domesticated international law, or maybe to like in Armenia for being a member of the ICC. Since 2023 and 2024, we have made some resources in Kurdish language. We have translated the Rome Statute, the element of crimes, the facts about the ICC and the four Geneva Conventions into Kurdish language, because we didn't have any resource in Kurdish, in our own Kurdish language about the international law, international criminal law, and the documents. And in 2023 to 2024, we have created some practical manuals. The responsibility of the organization is, being a bridge between theory and practice. We have developed a manual on IHL, international humanitarian law, and we have created a manual on fight trial according to international human rights standards, and we are about to create two manuals, manual on procedural aspects of international criminal law, that will be published within the next few weeks, and a guideline for the process for respecting of international standards. Based on these manuals, we have yesterday was Sarah, she mentioned, my colleague, she mentioned like capacity building needs for Armenia. It is the same for Kurdistan. Based on these manuals and resources, we have conducted trainings for the judges and prosecutors and lawyers. We have conducted summer schools for law students. Thanks Gordon, he helped us a lot in Kurdistan, and in Germany he was a part of these trainings. Yeah, and a part of our efforts is raising awareness of public work on international law. We have published infographics, some lectures, and we have conducted some conferences. Thank you so much.
That's okay, we can do it later. Let them say. Thank you very much, Mr. Ahmed. Next, I'll introduce Irene Victoria Massimino. Ms. Massimino is a lawyer specializing in international criminal law and human rights, and is the former co-founder of the Lemkin Institute of Genocide Prevention. Ms. Massimino has served as a rapporteur of the High Criminal Court of Buenos Aires Province, Argentina, where she focused on institutional violence, police brutality, gender violence cases, many of which became leading jurisprudence and became internationally known for their contribution to human rights. In this capacity, she became a member of the Provincial Roundtable for discussions to address the emergency situation in Buenos Aires province's prison system. Ms. Massimino works actively in the fields of internal and international conflicts, human rights violations, and atrocity crimes, especially genocide, in relation to the experiences of Argentina, Armenia, Nagorno-Karabakh, Bangladesh, Chile, Colombia, Guatemala, Iraq, Somaliland, Ukraine, amongst many others. She has served in international investigative delegations and trial observation missions. Ms. Massimino is a graduate of the Faculty of Legal and Social Sciences of the National University of La Plata in Argentina, holds a Master of Laws from Robert McKinney School of Law at Indiana University, and has a Master of Arts and Humanities in Human Rights from the School of Advanced Studies of the University of London. Ms. Massimino, thank you.
Thank you very much, Gayane, for that generous presentation. Thank you, everyone at CFTJ. This is the second time I'm here. It's very, very nice to be here. I don't think this is a conference. Really, it's an exchange of thoughts amongst people who have been working for Artsakh and the Armenians of Artsakh since 2020, really. And it's lovely to see for me so many familiar faces. I was asked to speak today about Argentina, where I come from, although in the program my friend Burgen put US. But it's okay, I won't hold it against him. To talk about the experience of Argentina, I hope I take 10 minutes. If I take more than that, please let me know. I can talk for hours, maybe without points. Anyway, as you probably know, Argentina went through, like many countries in the Southern Cone and the rest of Latin America, went through many dictatorships in the 20th century. Argentina had 6 dictatorships in the 20th century, being the last one of the bloodiest one, where approximately, it's a contested number, but because of the nature of the crimes, the numbers are always contested, but where approximately 30,000 people were victims and disappeared from 1976 to 1983. Argentina went through a terrible process of accountability. Why do I say terrible? Because it started very high up. Many of you probably heard of the 1985 Argentina movie that was a big trial to the military juntas and the heads of the guerrilla organizations. I won't get in the context, but that was really an important antecedent worldwide about trying for war crimes at that time and the new concept sort of arising of human rights violations. Unfortunately, due to the internal circumstances that Argentina went through in the immediate aftermath of the dictatorship and the trials, Argentina passed 2 laws of due obedience and full stop, which meant that nothing could be done happening later on. For almost 20 years, actually 20 years or even a little bit more, Argentina did anything. There was impunity in Argentina. In most countries of Latin America, there was a lot of impunity. And civil society organizations started organizing itself to find ways in which to have some form of accountability, but not only to punish perpetrators, and I want to highlight here, but to highlight the relevance of a trial for the purposes of addressing victimhood and also reconstructing the truth, not only legal truth, but a historical truth, even if that truth is partial, right? So I want to highlight, because we've talked a lot about perpetrators and identifying, and I think that's very, very important. But we must not, especially in international criminal law and human rights, gross human rights violations, to forget about the victims. And after I finish, I want to make a few comments on everything that has been discussed so far and my position on it. So finally, around the 90s, Argentina civil society organization, like out of 80s, 90s, started organizing itself and searched for justice abroad. Many of you might have heard of universal jurisdiction exercise in Spain, right? So Spain at that time was the hub for universal jurisdiction for Argentina, for Chile, for Guatemala. Many civil society organizations of victims and relatives of the disappeared went to Spain, and Judge Baltasar Garzón, who's still not in office, but still active in the process of accountability worldwide, especially now supporting a universal jurisdiction case in Argentina for the crimes committed during Franco's dictatorship. It's very interesting how history is very cyclical and goes in a cycle. Well, Argentina went to Spain. Spain was very, I don't know if the word is progressive. I apologize, my English is not my first language, but it was very progressive in understanding the nature of the crimes that had occurred in Argentina, identifying them not only as human rights violations, but possibly as the crime of genocide. I don't want to enter into that discussion, but I want to highlight the relevance of that process of accountability. That process of accountability, which not only happened for Argentina, but happened for Chile, as I mentioned, and happened also for Guatemala. Rigoberta Menchú, Nobel Peace Prize, was one of the leaders in bringing the cases to Spain. Set the path for pushing Argentina, Chile, and Guatemala's internal jurisdictions. I already spoke for 5 minutes. Anyway, I cannot believe it. Anyway, so what I'm trying to say here is we didn't have anything. Argentina was not trained. We were not prepared, although we had an incredible trial to the juntas. I don't want to take any value out of it. But for 20 years, Argentina did not have anything. Until a constitutional reform allowed Argentina to change everything, to become today a hub for universal jurisdiction. Laws were passed. So we carry now internal trials. I'm a high supporter of internal trials and actually of complementarity of jurisdictions, and I will try to make that a point of my presentation. But after many changes, Argentina became today one of the sources of universal jurisdiction, or one of the places where universal jurisdiction is triggered. Our constitution recognizes the need to respond to atrocity crimes that happen anywhere. You know, universal jurisdiction has really no connection to where, in terms of territoriality or personality, or except for the nature of the crime, with the jurisdiction that is being triggered legally. So Argentina became sort of, and is discussed in many international forums, as a place to have cases where there is an impossibility in the international scenario, like in the ICC or even special ad hoc courts. So we have now, and you probably heard, I was requested to briefly speak about the Myanmar case, although I'm not directly involved in the Myanmar case. Argentina issue, and it was mentioned in the previous presentation, that the ICC maybe will issue arrest warrants. Well, Argentina already did. We have international arrest warrants. Of course, this has its challenges, right? Argentina is, I don't want to say a developing country, I don't like those divisions. It's a country with a lot of economic hardship. Therefore, Argentina's judiciary, the federal judiciary, is in charge of universal jurisdiction, and it's our internal sources that take care of everything, every communication, and every sort of exchange with other international jurisdictions, right? So that is challenging, and it could become challenging. Spain, I cannot remember in which year, passed a law approved by quite a high number in the parliament. It was contested by quite a high number to limit universal jurisdiction. So Spain now is not a place where universal jurisdiction can easily be opened. I don't want to say that in Argentina it's easy to open universal jurisdiction. It's not, but it has become a very relevant venue for that. So what are the challenges that we face? One is the resources, as I mentioned. Argentina is, at this point, going through a very high economic crisis, and therefore that impacts the jurisdiction. And I want to bring complementarity. Complementarity was mentioned here a lot, and we all know when a country is unable or unwilling, then another jurisdiction is triggered. I think we have to think a little bit beyond that, and think that complementarity means supporting each other's jurisdictions. In the case of Myanmar, there is an investigation ongoing in the ICC, and there is, well, different nature. There is a case in the ICJ for genocide as well, and although it's, of course, state against state, I don't want to clarify the obvious, but we have similarly a case in Argentina for individual responsibility, criminal responsibility. So the ICC and Argentina are collaborating with each other in the investigation of the crimes. And this is something I want to highlight, because we often talk about one jurisdiction closing or one jurisdiction not being able to be triggered and another jurisdiction being triggered. And I think because of the nature of these crimes, the amount of... 2 minutes maybe? So the nature of the crimes, the amount of victims, we're talking about thousands of hundreds of victims. I was just in Colombia now, and the internal conflict of Colombia has reached approximately 10 million victims. 10 million victims, okay? Internal conflict, of course. So when we talk about these crimes, we have to think that we are not talking about ordinary criminal law. We have to set new standards here, and here comes my support for trials in absentia that Burgen always, we argue a lot about this situation. But anyway, the other challenge that Argentina faces is the impossibility of trying an individual in absentia. Of course, Argentina is evolving. We had a bombing, unfortunately, 2 terrorist attacks in Argentina in 1993 and 1994. One was in Diamia, which is, I don't know how to translate that, is the Asociación Mutual Israelita Argentina. It's an Israeli community, social community, etc. So now, recently, Argentina's court found 2 members of the Iranian government responsible for the ideological planning of the bombing. Therefore, Argentina, because of the impossibility of having them extradited, an unlikely situation of having them in Argentina, we are discussing the possibility of trials in absentia. And I think, and I know, I'm so sorry. I think these are the things that we have to discuss for, I said I will talk forever. These are the things we really have to discuss in forums like this. As practitioners, I know that sometimes we talk very academically and we discuss here academic and in abstract, but these are cases happening all over the world, in my country a lot, and we need that support, and we need to rethink a little bit those principles of international criminal law. I want to also especially thank Gayane and Hawre Ahmed who are here for your wonderful and very compelling speech this morning, and I hope I can be of support to you guys in Artsakh. Thank you.
Thank you, Ms. Massimino. Next, I would like to introduce our guest speaker, Dr. Taron Simonyan, Dr. Simonyan works as an associate professor at Yerevan State University and is a founding director at Pan-Armenian Projects Foundation and a founding partner at L Partnership Law Firm. He holds former experience as a national correspondent of the Republic of Armenia in the United Nations Commission on International Trade Law, arbitrator and member at the European Arbitration Chamber in Brussels, Belgium, and the director of the International and Comparative Law Center. Dr. Simonyan also has over 40 scientific publications, including monographs and articles on international law, theory of law and state, philosophy of law, as well as civilizational features of Armenian society, state, and law. Armenian society, state, and law. He graduated from Yerevan State University Department of Law with honorary distinction, holds a master's on European law from Yerevan State University, graduated from the Fletcher School of Law and Diplomacy International Legal Studies, studied at Tufts University. He did his PhD in Theory and History of State and Law at Yerevan State University. Dr. Simonyan.
Thank you very much. Dear honorable guests, dear honorable colleagues, it's my honor to be part of this very great event. I thank you very much our foreign colleagues to be part of this event, because I do really understand that it's very, very difficult to be a protector of law and also to be part of a struggle for justice, for human rights and the rule of law in our current political reality. Not that the world has been changing rapidly, and the international legal order we knew before maybe is not in force now, but we still use this wording coming from the international legal order, previous maybe. In any case, it's our dignity to be part of this struggle, to protect the law, protect the human rights, and to struggle for general justice nowadays. You know, I was asked today to speak about criminal proceedings that we have right now in Armenia concerning Artsakh issue and also concerning the atrocities committed by Azerbaijani authorities, and also a little bit about Armenian legislation covering the universal jurisdiction issues. Starting from the criminal proceedings, I must say that there are lots of criminal proceedings initiated by the Armenian authorities, especially the investigating committee. Before 2020 war, during it, and after it. And I can say that almost all articles on international crimes have been used for initiating these criminal proceedings, starting even from aggression. For example, there are a few cases concerning the aggression, even starting from before the war 2020. It was an aggression from the Azerbaijani side in July 2020. It was aggression in the border, in the northeastern border of Armenia, Tavush region. And another case, one case was initiated on this regard. Another case was initiated in September 2020, after starting the war. And the other one was in May 2021, when Azerbaijani forces invaded the Sunik region and also Gerarkunik region. And there were some statements from international community, from the United States of America, from France, from European Parliament, condemning all these atrocities, but still Azerbaijani forces are in the territory of Armenia. There was another case concerning Azerbaijani invasion in September 2020. 2022, sorry. In this case, also Azerbaijan invaded Sunik region, Bayot region, and also Gerarkunik region, and even they get closer to Jermusi, and they are still there now. Another case was initiated in May 2023, when Azerbaijan invaded Sot city in Gayane region. So all these cases are about aggression. We do have another cases concerning war crimes from 2020 to 2023. And I can list all the articles that were used for initiating all these criminal proceedings, like war crimes committed against a protected person, war crimes against property or other rights, war crimes using prohibited methods of warfare or means of warfare, outrageous treatment of dead bodies of those killed on the battlefield, destroying, damaging, illegal taking or seizure of cultural property during the time of war or an armed conflict, or changing their cultural value, destroying or damaging cultural property in order to provoke racial, national, ethnic or religious hatred, and mercenaries. All these are about war crimes, and we do have cases concerning all this. We do have cases also concerning crimes against humanity and also genocide. For these very particular cases, there are a few factual bases, like illegal blockade of Berzer corridor, illegal establishment of checkpoint in April 23, 2023 in Hakkari Bridge, deliberate resort to provocation on a Hakkari Bridge on June 15, 2023, and the complete blockade of all humanitarian passengers transporting and cargo transportation in both directions from Armenia to Artsakh and vice versa. The regular disruption from December 22 and from March 20, 2023, complete cut of all supply of gas and energy from Armenia to Artsakh, and at last, September 19, 2023, the complete or partial physical destruction causing serious damages to health, creating living conditions aimed at it of the civilian population of Artsakh, kept under siege from December 12, 2022 by armed forces of Azerbaijan. So these are all articles that have been used for initiating criminal proceedings. If you ask me what else the Armenian authorities have been done since, it will be very difficult for me to answer that question, because to my knowledge, nothing more. Just initiating criminal proceedings. Why? Maybe because of the geopolitical situation, maybe because of the negotiations with Azerbaijan and some others. It's not right, because in accordance with our legislation, the investigating committee is an independent, impartial, constitutional body with no connection to the government and executive bodies. So, regardless of the fact that we are in negotiation with Azerbaijan, regardless of the fact that it's very hard geopolitical situation, the rule of law cannot be forgotten. In any case, concerning universal jurisdiction in Armenia, the exercise of universal jurisdiction is justified, by the Roman concept actio popularis, which means that the state have a legitimate interest or locus standi to protect what older and hereby they are acting on behalf of international community to prosecute persons who are hostis humani generis. In support of this argument, we can say that certain international crimes must be prosecuted by also the Armenian authorities, even though those crimes are not committed in the territory of Armenia. Now, in 2022, in April 2022, the permanent mission of Armenia sent a letter to the Office of Legal Affairs of the United Nations defining the features of the Armenian legislation concerning universal jurisdiction, and telling them that in accordance with Armenian legislation, there are more than 50 articles that fall under the scope of universal jurisdiction. It's coming from genocide, crime, war crimes, till bribe or illicit migration. So there are more than 50 articles. But in order for universal jurisdiction to be applied by the Armenian authorities, there are 4 conditions. The first condition is that the perpetrator of a crime must be not an Armenian citizen or not a permanent resident of Armenia. The second one is that the crime must be committed outside of the borders of Armenia. The third one is that the crime must be defined by an international agreement to which Armenia is a party. And the fourth one is that the person who committed the crime hasn't been persecuted by other states. So these are the 4 conditions, and if we I'm finishing. If we take seriously, Armenia till now, to my mind, hasn't initiated any crime concerning universal jurisdiction. Even the crimes committed in the territory of Artsakh, based on that crime, several criminal investigations were initiated in Armenia, not using universal jurisdiction concept. But Armenian legislation, because all these crimes were against not only Artsakh but also against Armenia, and in accordance with the Criminal Code of Armenia, Article 12, Part 4, criminal proceedings must be initiated in all those cases where the Armenian interests are harmed. So that's it. Thank you very much. I hope I have finished in time.
Thank you very much, Dr. Simonyan. Next, I would like to introduce Mr. Kilian Schaefer. Based in Berlin, Germany, Mr. Schaefer is a criminal law lawyer and partner at Galen, Rechtsanwälte. He conducted a legal clerkship at the Higher Regional Court in Düsseldorf, held positions at the Chamber of Tax Consultants, and at a tax law firm specializing exclusively in economic and tax crimes, as well as at the German embassy in Sarajevo. Mr. Schaefer studied law in the Freiburg in Brisgau and Paris, and is a lecturer in student education at Free University of Berlin. Mr. Schaefer?
Thank you very much for the invitation to this conference. I would like to give you a brief overview of the legal framework of universal jurisdiction and its application in Germany. The German Code of Crimes Against International Law came into force in June 2002. The aim was to adapt German substantive criminal law to the Rome Statute of the International Criminal Court. The national regulations ensure that the German judiciary can prosecute the most serious crimes, genocide, crimes against humanity, and war crimes based on the principle of universal jurisdiction, regardless of where the crime was committed. Offences under the Code of Crimes Against International Law do not require double criminality. Courts may pass judgment even if the offence is not criminalized in the state in which it was committed. The law applies for the offences of genocide, crimes against humanity, and war crimes, even when the offence was committed abroad and bears no relation to Germany. That means, regarding the core crimes, Section 1 of the Code of Crimes Against International Law does not contain any restrictions on the use of universal jurisdiction. However, in practice, the prosecution has the discretion to refrain from investigating when certain requirements are not met. We will come to this point in a moment. Before that, I would like to point out that the principle of mandatory prosecution, regulated in section 152 of the German Code of Criminal Procedure, also applies to international crimes. According to this principle, proceedings are initiated if there are sufficient factual If there are not sufficient factual indications to open a formal investigation, an observation process, a so-called Beobachtungsvorgang, can be initiated. Observation processes are used to verify the existence of an initial suspicion or the application of German law to a specific situation from generally accessible sources without recourse to the investigative measures provided for in the Code of Criminal Procedure. In 2022, for example, the Federal Public Prosecutor opened 33 investigations and 721 observation processes. Most are based on criminal complaints, but some are also drawn up ex officio based on generally accessible information, for example, from crisis areas. The presence of the perpetrator, the suspect, in Germany is not necessary to start an investigation. The prosecutor, competent as the Federal Prosecutor General at the Federal Court of Justice, can open investigations to secure all available evidence for potential trial later. However, a trial in absentia is generally not permitted in the German legal system according to Article 103 of the Basic Law and Section 231 of the Code of Criminal Procedure. The accused must have the opportunity to defend himself against the accusations made against him. If the perpetrator has not yet been identified, structural investigations can be carried out. These are investigations that are conducted against persons unknown and initially serve to secure evidence with the aim of identifying offenders. The subject of the proceedings is not a specific procedural offense, but rather the overall complex relevant to international criminal law as such. Let me give you an example for structural investigations in the last years. In March 2022, the Federal Prosecutor General initiated a structural investigation concerning war crimes committed in Ukraine. This was later extended to crimes against humanity. An additional specialized unit has been created within the Federal Prosecutor's General Office to support these investigations. The prosecutors are currently gathering evidence, including statements from Ukrainian refugees. As already mentioned, German prosecutors are generally obliged, under the principle of mandatory prosecution, to investigate and prosecute all offenses under the Code of Crimes against international law, in order to avoid impunity and to gather evidence that could be useful in a subsequent trial in Germany or abroad. However, the procedural provision of Section 153F of the Code of Criminal Procedures gives the prosecutor the discretion to dispense with prosecuting an offense if there is no domestic link to Germany. The domestic link is missing if no German national is suspected to have committed the offense. The offense was not committed against a German national. No suspect is or is expected to be present in Germany, and the offense is being prosecuted by an international court or by the state where the offense was committed, or whose citizen committed the offense or was injured by the offense. In practice, prosecutors generally investigate all cases in which they can gather evidence in Germany or in which victims or witnesses are on German territory. On the other hand, they do not start an investigation if there is no possibility to gather evidence without mutual legal assistance unless the suspect is a German citizen. Prosecutors use mutual legal assistance but do not solely rely on this evidence to build their case. The prosecutors have discretion not to initiate initiate or discontinue an investigation if the ICC or a state with territorial jurisdiction or active or passive personality jurisdictions opens its own proceedings. However, it's insufficient if the prosecution in another jurisdiction is a pretext or without a genuine pursuit of justice. If no investigation is conducted by another jurisdiction, it's a legal duty of the Federal Prosecutor General to investigate under the principle of mandatory prosecution. The Federal Constitutional Court ordered in 2011, and I quote, "When it comes to cases which are subject to universal jurisdiction, however, there's a graded priority of jurisdiction. It is the state in which a crime took place and the home state of the offender and of the victims which are primarily called on to prosecute. Secondly, the International Criminal Court and, where appropriate, other international criminal courts, and thirdly, third states acting in accordance with universal jurisdiction. Over and above this, overstraining German investigation resources with cases which have no link to Germany should be avoided." And the quote goes on this basis, Section 153F of the Code permits discretion to be exercised in two directions. For cases with a domestic link, there's the obligation to prosecute as a matter of principle. If there's no such domestic link, however, it's possible to dispense with prosecuting a criminal offense, in particular if prosecution is being carried out by an international court of justice or by the country in which the offense was committed, or in the home state of the offenders or victims. Before ending my input, I would like to show you a few figures on the investigation proceedings initiated by the Federal Public Prosecutor General on the basis of universal jurisdiction. You can see here the numbers from starting before 2009. Oh, I'm sorry. Okay. So we have for the years 2017 and 2019, I don't have any numbers for each year because it's not easy to find the data. But for 2019 and 2022, we have one structural investigation that was Ukraine, and we have 117 investigations against specific persons. The crimes of the 117 investigations relate primarily to Syria, Iraq, but also to Afghanistan, Eritrea, Gambia, Yemen, Congo, Libya, Mali, Nigeria, Pakistan, and Chechnya. The results, 16 indictments on charges under the Code of Crimes Against International Law. By July 2022, 9 final judgments had been issued in these proceedings. More recent data is not available since 2022. Then we have, in these cases, not only universal jurisdiction, because we have in many cases a universal jurisdiction combined with jurisdiction under the criminal code. That means proceedings solely under the Code of Crimes Against International Law. We had, for example, state torture in Syria that was took place in the Higher Regional Court in Koblenz. It was the first trials to deal with crimes under international law committed by the Syrian Assad regime. These are proceedings solely under the Code of Crimes Against International Law. And we have many other proceedings under the Code of Crimes Against International Law related to terrorism. That means we have the sections 129A and 129B of the German Criminal Code in connection with a war crime pursuant to the CCAL. That means these cases are not solely universal jurisdiction cases, because we have always the jurisdiction of Germany because of the forming terrorist organizations according to the German criminal code. Here, for example, foreign fighters, men and women who travel from Germany to combat zone and fight there, for example, alongside the so-called Islamic State or Syria returnees. Here you can see, that means solely CCAIL, the criminal code against international law. From 2017 to 2019, we had 71, that means 67% and 33%, and in the years after it was it changed a bit, and for I think 2023 we have nearly 50. Thank you very much.
Thank you very much. We'll start our Q&A sessions with a few questions. If anyone has any questions, please hand it to our volunteers. Okay, thank you. So we'll ask with a few questions for Mr. Ahmed. Can you describe the specific legal and logistical challenges faced in prosecuting former ISIS members in Iraqi Kurdistan?
In Iraq, first of all, there is not will for criminalizing, core crimes. All of the ISIS fighters have been prosecuted. It's true, ISIS was a terrorist organization, but they committed war crimes, crimes against humanity, and the crime of genocide against the SD community. And the SD community needs to have this kind of judgment, because this kind of judgment is like a stamp of history. That's why Armenians, Kurds, and some of the victims around the world, they need us to have judgment for according to what the crimes that they have gone through genocide, for example. Another issue, another challenge, I think, in Kurdistan and in Iraq, there are some fluctuations, some political fluctuations between Iraq and Kurdistan. Like, for example, during the negotiation for establishment, the special court for ISIS, the big question was, okay, the court would be able to prosecute, the perpetrators, the ISIS members who committed crimes inside Iraq but outside the Kurdistan territory. How is the dynamic for transferring, the ISIS fighters between Baghdad and Kurdistan? Another challenge could be like procedural aspects for international criminal law, because there are a lot of gaps in the Iraqi procedural criminal law in Kurdistan, and maybe financial challenges, because right now there's a big problematic issues between Kurdistan and between Iraq. I see, but it needs time. And maybe another issue which we are working on it, we don't have, it was one of our main questions, how many professional judges do you have, professional lawyers, for dealing with core crimes? If you see the judgment of the Iraqi High Tribunal in 2008 and 9, which there were a lot of judgments that came out in the ICTR and ICTY. But if you comparison that, the judgment of the IST and the ICTR and ICTR and ICTY, so you can differentiate that it's not like a judgment in an international criminal court. It's like a judgment in a local judgment because of the mentality of the judges.
Thank you. How many ISIS members have actually been tried and convicted, if any?
How many?
Yes.
Actually, I don't know, but maybe more than 5,000, but just in Kurdistan.
And do you work with any organizations in collecting evidence?
We need that, unfortunately, by the request of Iraqi government at the end of this week. They have done a great job for evidence collection. And there are another institution in Kurdistan region of Iraq, which is a part of Judicial Council. The director of the institution is Judge Ayman. He was one of the participants of our training. They already collected and they already shared some evidence with Germany, Netherlands, and in France. And of course, just some weeks ago, UNITA published last report and says so far just they served it, through sharing evidences, they served 15 cases in third party. And there are, like, for example, Yazidi organizations, they are working on evidence collection. And I would like to ask Center for Truth and Justice to work in Kurdistan, especially for the Yazidi community, for documentation, because you already have experiences here in Armenia. Thank you.
Thank you.
I think.
What role do local Iraqi Kurdish initiatives play in supporting these prosecutions, and how effective have they been?
Kurdistan can play their crucial role for accountability for ISIS through evidence, sharing evidence, through having like a channel between, any prosecutions around the world and the victims in Kurdistan. But to be honest, I think the effort for having this kind of role within the Kurdistan region of Iraq and in the Kurdistan government and institutions, there are not like a real willing for supporting victims, because I mentioned it when I was talking about the Iraqi High Tribunal, the mentality of some of people. I wish it will not happen here, because some of the mentality of in Kurdistan, in Iraq, they have retributive mentality just for prosecuting and killing ISIS, not like for having a fair trial. So maybe the Kurdistan region of Iraq can do that. Of course, in support of the international community for paving the way for restorative justice and transitional justice for the Yazidi community, because Yazidi is scattered around the world and they are shattered, so they need a lot of support.
Thank you. I would like to go back to the number of convictions you mentioned. Did you say 5,000 convicted, and also have they been sentenced as well?
I don't think actually, but I think more than 5,000.
530, or I apologize. Repeat that. How many?
5,000.
More than 5,000.
Just we collected around 3,000 cases in 2021 and 2019-2021.
Thank you. And how do prosecutions in Iraqi Kurdistan coordinate with efforts in other states to ensure accountability for ISIS crimes?
The body which is a part of the Judicial Council, they are working on evidence collection, and I am aware, it's based in Doha, and I am aware they shared evidences with Germany and Netherlands for some cases, and still there are a good cooperation between them as far as I know.
Thank you. And what's the main political problem behind not having the law on punishing former ISIS members?
We have a law, but it's anti-discrimination law. We don't have a real law for international crimes, and I think it's about not understanding of the political leaders for importance of incorporating international criminal law into domestic system. It needs time. So we should have hope, and we need to keep our work in our efforts for making them, or to persuade them to having or to criminalizing core crimes in Kurdistan and in Iraq.
Thank you very much, Mr. Ahmed. I would like to address my questions to Ms. Massimino. What lessons can be drawn from Argentina's experience with international criminal law, particularly regarding Rohingya cases?
Thank you, Gayane. I think it's not only the Rohingya case that can be drawn as an example. Here, the colleague from Germany mentioned quite a few cases. Argentina also has against China, Saudi Arabia, Venezuela, actually very recent one, where I think an arrest warrant was issued again, Myanmar, etc., and so on. I don't remember all of them. Something I wanted to highlight, and probably one of the most important aspects from not only the Rohingya case, but every special international criminal law case, is the role of the representative of the victims or the civil party in Argentina, something I did not mention in my speech, but I wanted to bring to you. Argentina, through the development of many years of trials for crimes against humanity and genocide, established almost a full autonomy to pursue both the investigation and later on the trial by the civil party, even if the prosecution denies to do so. Although it's a struggle, and the majority of the investigations that have been opened in Argentina through universal jurisdiction have been done in the appellate level. Argentina has this particular, sometimes difficult to understand for other countries, this particular situation where I don't know, the translation is very difficult. It's not really the civil party. It's not either the representative of the victim fully, but can pursue the trial. The Supreme Court, a couple of years ago, confirmed that even if the prosecution opposes to sending a particular case to trial, the civil party or the representative of the victim can do so by itself. So I think it's one of the most interesting aspects of this particular cases, especially for universal jurisdiction, when sometimes prosecutions can be a little bit reluctant to work as hard as it needs to be with all the difficulties of investigating a crime that happened maybe thousands of kilometers away from the jurisdiction we're trying to trigger.
Thank you so much. The next question would be, how was Argentina's legal framework adapted to address crimes of international concern?
Argentina has been developing its framework for many years. In 1994, in particular, we went through a constitutional reform that incorporated a lot of human rights treaties with constitutional hierarchy. So we are not only and interpretations of courts, of international courts, like the Inter-American Court of Human Rights. So everything that the specific international human rights treaties that Argentina has signed and ratified that are incorporated within Article 75 of our Constitution, and the interpretation of the different bodies within the international community, especially the regional system for protecting human rights, are considered with constitutional hierarchy in Argentina. This, of course, has changed, as here Hawre was mentioning, the mentality of lawyers, of judges, of prosecutors, etc. And we have become quite welcoming. Courts and both prosecutions have become quite welcoming of those lawyers that are especially expertise in international criminal law and international human rights law. Of course, this is not from one day to the other. This has taken actually 40 years since the recovery of the democracy in Argentina after the ending of the dictatorship. And it was probably one of the most important challenges is to understand, for example, the concept of genocide, right? And the particularities of the concept of genocide. So, but we're still working on it. Experts give testimony in trials, experts on genocide that are not lawyers, but a lot of from different fields. So we are very open now to this, and of course we have a very good regional system of human rights that has guided a lot of these principles, including the need to speedily or fast opening any case related to crimes against humanity, genocide, or crimes of other international nature.
Thank you so much. My next question would be for Dr. Simonyan. Dr. Simonyan, you mentioned crimes being prosecuted. So just to clarify, are you in the investigation or prosecution phase?
Most of them are in the phase of investigation.
Okay. And is this information public or it's closed?
Most of them are public, but maybe there are some closed information. I don't possess them.
Okay, thank you. And my next question will be for Mr. Schaefer. Hi. How do you approach representing victims of international crimes before German courts? And what are the obstacles in securing justice for victims in these cases?
Yeah, as I tried to point out, the first hurdle is definitely to initiate an investigation, and after that, it's important for a lawyer to use the rights of the victims that they have according to the German Criminal Code of Procedure. That means they have the right to appoint a lawyer. The lawyer has the right to get file inspection. Then the victim has the right to get translations and an interpreter. The victim has the right to get, if necessary, the right to protection. So, for example, in a witness protection program. And we had a reform of the Criminal Code of Procedure this year, and now the victims of crimes against international criminal law are now can be plaintiffs, joint plaintiffs, according to German law. And as a joint plaintiff, you have further rights, procedural rights, for example, attend at the trial. Apply for rejection of judges, apply for the rejection of expert witnesses, question the defendant and witnesses, challenge orders of the presiding judge, introduce evidence, make statements, receive the same information as the prosecution, and appeal decisions on the court. So it's important to know these rights and to use these rights in the proceedings.
Thank you. And this question is for all speakers, all panelists. Is it conflicting that different jurisdictions investigate same crimes parallelly?
Sure. Thank you. No, I don't think so. Of course, there are different stages in the criminal process, and I think it's what I was trying to say earlier, that we need collaboration in this. I mean, the nature of the crimes, the amount of victims, the amount of perpetrators requires maybe the collaboration of other jurisdictions. So I think this is a discussion we have to set principles on international criminal justice that are particular to international criminal justice and law and the practice of it because of how relevant these crimes are and how impactful they are in societies, as we can see. I mean, from all of the testimonies we heard, the videos that Gassia shared, these are not ordinary crimes, and we have to realize about this.
Thank you very much. Anyone else? Okay. Dr. Simonyan, this question is for you. Do you believe it's worthwhile to incorporate universal jurisdiction more extensively within Armenia's legal framework?
Can you repeat the question?
Yes.
And the name.
Do you believe it's worthwhile to incorporate universal jurisdiction more extensively in the Armenia's legal framework?
Yeah. Okay. Well, of course, legally, we are one of the nations that has faced lots of international crimes. So we should be one of the nations that are in the first stage against international crimes and in this very first part of the struggle against those crimes. So universal jurisdiction is one of the tools in this struggle. So we must be in this struggle. Another point of view, there have some of our politicians, they think that Armenia is a small country and it's very difficult for us to struggle in this regard because we are in a very difficult geopolitical situation. The geography is not good enough, and in each case we act in the framework of universal jurisdiction. There could be lots of difficulties for Armenian citizens and also for Armenian states. So we have legal point of view and we have political point of view in this struggle. For me as a lawyer, yes, of course, we must be in the first stage and we must be one of the first nations in this struggle. As a former politician, I do understand them who speak about that. So it depends on a crime, on a state, on a prosecutor, on other different factors.
Thank you. And my next question would be, how does Armenia's approach compare to other countries with similar legal provisions? If you have done any studies on that.
It's very difficult to have one definition for the Armenian approach because our government and also some political leaders do not give very clear definition for their approaches. So having known them in person and also their abilities in this regard, it will be very difficult for me to define the final Armenian approach. I can say there are some populistic approaches to that, and there are Armenian lawyers speaking about this concept, but to have a final definition for the Armenian state's approach, it will be difficult for me to say.
Thank you very much. Mr. Schaefer, this one is for you. Can you provide examples of successful cases where universal jurisdiction has been applied in Germany?
Yeah, I mentioned already the first trial dealing with Syrian state torture as crimes against humanity. Then also we had the first trial to define the ISIS attack on Yazidis in Iraq as a genocide. The trial was remarkable in several aspects. It's the first trial based on the principle of universal jurisdiction addressing crimes under international criminal law that were committed abroad by a perpetrator who is not a German citizen and who was only extradited to Germany on the basis of an international arrest warrant. And the third one to mention could be the first trial to hold a member of the Gambian killing squad, the Junglers, accountable.
Thank you very much. And my next question is, what are the primary challenges in gathering evidence and securing cooperation from other states in these proceedings? It's for you, yes.
Yeah. As Mr. Kramer yesterday already mentioned, collecting evidence is always a lot of work, and many witnesses might suffer from severe traumas, and so it's always difficult to get the information that the victims and the prosecutors need to investigate the case. Mutual legal assistance is always an issue, and it works often not in crisis regions, so that's why I said before the German prosecutors need or want further evidence and do not build the case only on mutual legal assistance. Then we have translations problems. I mean, this is already mentioned here. And
Thank you so much, and thank you so much to our panelists for participating in the CFTJ's conference.